All right, court is calling 2021 CR 10247, State of Texas versus Anthony Salinas. For the state, please.
Michael Villarreal, state.
Michelle Hayden for the state.
For the defense.
John Young.
Anthony Salinas.
All right, both parties have received the charge of the court. Is there any objection to the charge, state?
No objection from state.
Defense.
No objection, Your Honor.
All right. Is there anything before bringing the jury in?
Your Honor, my client has asked to speak to the court before the jury comes in.
For what purpose?
I believe that he intends to complain about my presentation of his defense.
All right, so we will bring the jury in for closing arguments, and then I will allow Mr. Salinas to say whatever he wishes to say after closing arguments.
Thank you, Your Honor.
All right, for the jury.
All right, everyone, please be seated. Guys, we were so close to 9 a.m., but 9:06, I think. All right, ladies and gentlemen, the jury, you received all the evidence in this case. I'm going to read to you what is called charge of court. You will be given a copy of this when you go back to deliberate. Charge of the court. Members of the jury. The defendant, Anthony Salinas, stands charged by indictment with the offense of violation of conditions of bond in a family violence case, alleged to have been committed on or about the 14th day in August 2021 in Bexar County, Texas. The defendant has pleaded not guilty. 1, our law provides that a person commits the offense of violation of conditions of bond in a family violence case if, in violation of a condition of bond set in a family violence case and related to the safety of the victim or the safety of the community, the person knowingly or intentionally commits family violence. 2, family violence means dating violence, and it also means an act by a member of a family or household against another member of the family or household that is intended to result in physical harm, bodily injury, or assault, or that is a threat that reasonably places the member in fear of imminent physical harm, bodily injury, or assault, but does not include defensive measures to protect oneself. Dating violence means an act other than an offensive measure to protect oneself by an actor that is committed against a victim with whom the actor has or has had a dating relationship, or because of the victim's dating relationship with an individual with whom the actor is or has been in a dating relationship and is intended to result in physical harm, bodily injury, or assault. Dating relationship means a relationship between individuals who have or have had a continuing relationship of a romantic or intimate nature. The existence of such a relationship shall be determined based on consideration of 1, the length of the relationship, 2, the nature of the relationship, and 3, the frequency and type of interaction between the persons involved in the relationship. Assault is committed by a person if that person intentionally or knowingly causes bodily injury to another. Bodily injury means physical pain, illness, or any impairment of physical condition. 3, you are instructed that Article 17.40 of the Texas Code of Criminal Procedure, conditions related to victim or community safety, states to secure a defendant's attendance at trial, a magistrate may impose any reasonable condition of bond related to the safety of a victim of the alleged offense or to the safety of the community. 4, a person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. 5. Now, if you find from the evidence beyond a reasonable doubt that on or about the 14th day of August 2021, Anthony Salinas did knowingly or intentionally violate a condition of bond set in a family violence case and related to the safety of the victim or the safety of the community, issued in Bexar County, Texas, dated the 7th day of May 2020, under cause number CM 70892, issued under the Texas Code of Criminal Procedure, Article 17.40, by intentionally or knowingly committing family violence against Denise Valdez, by striking Denise Valdez with a cord or striking Denise Valdez with a wire, then you will find the defendant guilty of the offense of violation of conditions of bond in a family violence case as charged in the indictment. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. You are instructed that if there is testimony and or evidence before you in this case regarding the defendant having committed an offense or act of misconduct, if any, other than the offense alleged against him in the indictment in this case, such testimony and or evidence cannot be considered by you for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such offense or act of misconduct, if any, and even then, you may only consider the same in assisting you, if it does, in the contextualizing the nature of the relationship between the complainant and the defendant in this case, and for no other purpose. You are instructed that the grand jury indictment in this case, or any other indictments related to any other cases, are not evidence of guilt. A grand jury indictment is the means whereby a defendant is brought to trial in a felony prosecution. Indictments are not evidence, nor can they be considered by you in determining whether the defendant is guilty or not guilty. Our law provides a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected to not testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. Written or recorded statements made by a witness to investigators or other officers, or police reports made by officers intended by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. Do not let bias, prejudice, or sympathy play any part in your deliberations. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, or computer, the internet, or any internet service, or any text or instant messaging service, or any internet chat room, blog, or website to communicate with anyone any information about this case, or to conduct any research about this case until I accept your verdict. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but the law of the case you must receive from the court as contained in these instructions and be governed thereby. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact or verdict to be reached in this case. No such indication was or is intended. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate form attached to this charge and signing his or her name as presiding juror. The form is not intended to suggest to you what your verdict should be. Your sole duty at this time is to determine whether the defendant is guilty under the indictment in this cause and restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. If the jury wishes to communicate with the court, the presiding juror shall notify the bailiff. Any communications relative to the case must be written, prepared by the presiding juror, and shall be submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court. Verdict forms are attached. State, are you ready to proceed with your closing arguments?
Yes, Your Honor.
All right, State.
Good morning, ladies and gentlemen. Thank you for your time and attention this week. I'm just briefly going to go over the evidence and the elements and some things to keep in mind during your deliberations. Defense will present their closing argument, and then Michael will go over the case in more detail. So the charge that the court just read to you probably sounds pretty complicated. It's probably going to look pretty complicated, but it's really not when you break it down. So again, I just want to go over the elements, what we have to prove, and the only thing we have to prove and what we've proven to you is that on or about August 14th, 2021, in Bexar County, Texas, Anthony Salinas intentionally or knowingly violated a condition of bond set in a family violence case and related to the safety of the victim or the safety of the community, issued in Bexar County, Texas, dated the 7th of May, 2020, under CM 70892, issued under Texas Code of Criminal Procedure 1740, by intentionally or knowingly committing family violence against Denise Valdez by striking Denise Valdez with a cord or striking Denise Valdez with a wire. Now, you have to be able to check all 7 of those boxes, but how you get there doesn't matter. So if 11 of you say, oh, I remember August 14th, 2021, but one of you says, oh, I thought it was August 15th, 2021, that doesn't matter. Or 6 of you say, oh, it sounds like you struck her with a cord, and 6 of you say, oh, I thought it was a wire. That doesn't matter. You just have to be unanimous as to all 7 elements. And most of these elements haven't been an issue in this case. Bexar County, Texas. We know 2307 Ore Drive is in Bexar County, Texas. We know that's Anthony Salinas. The only one that's really been an issue is number 7, which defense is trying to say that he didn't do. So don't spend a lot of time focusing on elements that haven't been an issue in this case. Now, the evidence that you've heard this case, just to go over it, you heard from a number of witnesses in this case. The first witness that you heard from was LaSonia Robinson, who's the 911 custodian. The purpose of her testimony is just so you could hear that 911 call. And that's when the events were most fresh in Denise Valdez's mind, right after the incident happened. Now we know that defendant was over at the house at about 5:30 in the evening, and she called 911 right after that. And that's when the events were most fresh to her mind. So that's why we wanted you to hear that. Then you heard from the fingerprint examiner, Vincent Villarreal. And he told you about the physical evidence that's admitted, the documents in this case, which you guys are going to go back there and take a look at. But first, that condition of bond in the family violence case. That's State's Exhibit 1. You guys can go back there and look at it. And then he went over the indictment, State's Exhibit 2, which shows you it was a family violence case. The charge in that talks about the family code, and it also states that the defendant threatened the victim with a gun. That is family violence. We already know they have 2 kids together. We already know they had a prior intimate or dating relationship. That's clear. And then he went over the 2 judgments in this case. The aggravated assault with a deadly weapon conviction and the assault family violence second offense conviction, showing you the nature of the relationship between these 2 people. Then you heard from Denise Valdez. And say what you want about Denise, not the most eloquent speaker, confused at times, but she is consistent with what happened to her. Those injuries, she could have done that herself. You have pictures of the injuries. She called the police right away. She's consistent with what she tells you about what happened. And that's consistent with all the evidence that you've heard in this case. And that's consistent with the elements, what's important. Next, you heard from Officer Wallace with FAQ. He told you he went over there. He made contact with Denise. He saw those injuries. He said she couldn't have done those for herself. They were fresh. She's bleeding. He told you he talked to a child witness at the scene whose story was consistent with the victim and whose story was consistent with the injuries, and all that evidence was consistent with each other. Then you heard from Detective Rollo, who went over her investigation, talked about interviewing people at the scene, talked about the injuries, talked about the law involved in this case, the order, and just basically went over all those elements and what we have to prove again. Now let's talk about the physical evidence you get to take back there in the courtroom. State's Exhibit 5, that 911 CD. Take it back there and listen to it. You need to shake it up. She gives you the account of what happened that day. It's been almost a year since then, but you have the account of what happened that day. Next, you've got State's Exhibit 1, the bond condition, no contact. The defendant, Anthony Salinas, you can read it right there. Under CM 70892, offense, violation of protective order 2 priors, he's ordered to have no contact with Denise Valdez for her protection. And we know he was also ordered GPS partial house arrest. He had a GPS monitor on. And why is that important? Well, that came out from defense's witnesses that after he committed this offense, he cut his monitor when police were looking for him. Does an innocent person do that? No. Why would he cut his monitor? Because he knew he screwed up. And you've got State's Exhibit 2. The indictment for the case for which the bond order comes from, a family violence case, and I just put that up there. Again, it shows you defendant was accused of threatening or harassing Denise Valdez by entering her house and pointing a gun at her. Clearly family violence. Again, you've got the judgments you can take back there and look at. State's Exhibit 3, the aggravated assault with a deadly weapon judgment, and State's Exhibit 4, the assault family second offense judgment. You've got the photos in the case. You can take those back there and look at them as well. Then you heard from defense witnesses. First one, Rebecca Menchaca, who told you that in 2019 she went to prison for burglary of a building. She also waits almost a year to come forward with her story about how the defendant was with her. She also told you that after 4 o'clock she wasn't with him. Well, we know he was at the victim's house at about 5:30 in the evening. Then you heard from Amy Sanchez, who tells you, yeah, the defendant was staying with her, but she didn't see him after that morning. What's the point? Then you hear from Crystal Salinas. She didn't see the defendant until after 6 p.m. So after this crime has been committed, both Crystal and Amy told you he cut off his GPS monitor. Evidence of guilt. Seems like the only reason to put those witnesses up there were to make you feel sympathetic that the defendant's dad had passed away. Now, what's not evidence? The police reports, that's just used to refresh the officer's memory. You don't get copies of that. You also don't get a transcript of the entire testimony in the trial. If you have a specific dispute as to a specific piece of testimony, then
2 minutes.
you can ask for that to be read back, but you don't get a transcript of the entire thing. So I asked you when looking at this case, it's your job to evaluate the credibility of the witnesses and evidence and ask what evidence is consistent. The injury she sustained, the account of what happened to her, that is all consistent. Doesn't matter if the truck was maroon or green, that doesn't matter. That doesn't go to the elements. Again, you must not take bias, sympathy, or prejudice into your account in deciding this case. You can't say, I felt sorry for him because his dad passed away. His dad did pass away, and I'm sure he was very upset that day, but he took it out on the wrong person, and he committed this offense. Beyond a reasonable doubt, it's not 100%. You may have questions as to what color was the truck? Why were they at Taco Cabana? What were they fighting about? It does not matter. We have proven all those elements to you beyond a reasonable doubt. That other stuff does not matter. Enough is enough with Anthony Salinas. Find him guilty.
All right, defense.
Thank you, Your Honor. Okay, the elements of the offense. There are 7 or 8 elements. There's 2 of them that are rather kind of important. You can't find that some elements are true in order to convict. You have to find that all elements are true. Yes, this couple has a horrendous history. Yes, my client's been in prison. 4 cases involving the same person. Yes, he had a bond requirement on another family violence case that said he can't have contact with her. And he's been accused of knowingly and intentionally having contact with her, right? That's all those things are easy. We're looking at August 14th. As the judge's instruction said to you, all those other issues, all those other cases are given to you only to give you context and to basically be the jurisdictional base for this charge being brought. Assault, striking with a court. The prosecutor said something very, I guess, flamboyant. Said it was impossible for her to have inflicted this injury herself. Look at the injury when you see the photographs. The injury goes diagonally. Remember, I had to reach up. It goes diagonally from where her hand would be down to the lower left side of her body. Would a person coming up behind you and whipping you with a cord with that kind of injury, or would it be more likely that a person whipping themselves with a cord would cause that diagonal injury? It's not cut and dry. Who inflicted this on her? All right, Denise Valdez. She's a great witness. Prosecutor asked her questions, went right down the timetable. It's great. She said she was standing there in her driveway by the carport And he pulled in and jumped out of the car and was screaming and hollering at her and chased her down with the cord and whipped her. And then she ran into the house and she locked the door. Came in anyway. And then we get to the room for her daughter's room, her deaf mute daughter. And for some reason, he didn't go in the room. And he continued to scream at her. I guess that's why the deaf daughter didn't testify, because she didn't see anything. She says that he came to her home. Okay. If that had happened, he would have known what intentional violation was on, right? That's pretty straightforward. But on cross-examination, she says, oh yeah, wow. You know, that's not what happened. She got no medical treatment. And while the prosecutor says it doesn't have anything to do with it, and it doesn't, but why did she say green truck? Because that's the truck he usually drove. All right. The second story, on cross-examination, I asked her, do you remember going to the Taco Cabana? No. Wait, oh yes, I did. Well, how'd you get there? Well, my daughter drove me there. My client knowingly and intentionally violate. No. She came and found him. Now, we have the Miss Franchata, who was in the back of this truck. And I'm assuming that means the crew cab. And she's a somewhat substantial young lady. And she said she was sitting there and she didn't get along with Denise, so she didn't say anything. She got into the truck. And it was weird. He was in the bathroom washing up. Came out, got in his truck, and there she is. He says, get out of my truck. Now, her story was that he made her drive the truck to her house on Orr Street. But she said, no. She wasn't driving the truck. She stood over, she got in, and was getting ready to drive off. And we realized we had another passenger. Wanted her to get out. She wouldn't get out. Doesn't want to get into a physical altercation, holding her out of the truck. So he takes her to the last place he knows that she lived and drops her off. Franchata is still there. She watches the whole thing. He never got out of the truck. Denise did. She goes into the house. Lest there be confusion, I tried to get Denise to say, was there more than one contact? There was only one contact that day, the 14th of August. And that was when she went to the Taco Cabana, intruded herself upon my client, wouldn't get out of his truck, and he took her home and dropped her off. And we're just unbelievably fortunate that Denise didn't realize, I guess, or didn't care, had selective memory, didn't know there was a witness to the whole thing. The relationship between Mr. Franchata and my client, they're co-workers. They do this resurfacing of countertops, and they go to a lot of different places. With him most of the day, saw these events, saw him get the notification of his father's death, saw the way that he broke down. They were going, they left their route where they were giving bids. He suggested to him that he clean up because he was distraught. While he's in there, Denise shows up. Was there an assault? There is some evidence that there was, because there was the whip mark across her shoulder down to her left side. As I said, I think that's somewhat problematic. How that occurred, we don't have any medical treatment. We would have had some evaluation by an expert on how that could have been evaluated. We don't. After Mr. Menchaca was with him and he dropped off Denise, he took her and dropped her off so he could then go to his brother. She said he started toward, I think it was Marbach, in the direction of his brother's house. Then Crystal Salinas, his niece, the daughter of the owner of the house, my brother, so she saw him arrive. Both she and Mr. Menchaca said it was clearly a burgundy truck. It was not a green truck. Even though that's the truck he normally drove, it was a green truck. She saw him get a phone call and he cut his monitor off. Now, prosecution has said that that's obviously evidence of guilt. It's also evidence of a man who wants to go to his father's funeral and he knows that the Deese has done this again and he's going to wind up getting arrested. So, what does he do? He cuts the monitor off. And his niece abused him verbally for that, told him what a fool he was, and unfortunately, in our society, being a fool is not a crime. But he was a fool. He was there till after dark, there continuously during the whole time that Denise says this incident occurred. Either that or Mr. Menchaca was there. Remember, it's important. There was only one contact between these two people that day, not two. Prosecution's theory that he somehow went back over to Ms. Valdez's house after he dropped off Ms. Menchaca has been denied by Ms. Valdez. Said he only saw her the one time. From when she went to the Taco Cabana, intruded herself upon it, and he took her home and dropped her off, and then went to his brother's house. As I say in the Army, I said all that to tell you this. You have to find the evidence convincing beyond a reasonable doubt that the client intentionally and knowingly violated the protective order in a family violence case and inflicted harm, physical harm, by striking Denise with a cord or wire. Those things, you have to find each one of those beyond a reasonable doubt true. Prosecution mentioned that this happened in front of Denise's daughter and her friend. Neither of whom you heard from. Denise has already told you once. Why? I don't know. Probably because she knows the elements of this charge, the knowing and intentionally. So she didn't initially want to tell you or the prosecutors that she went to where he was, not he came to her house. There's a little difference between, I was standing there in my driveway and he showed up in his truck and jumped out and attacked me. That's bad, right? Okay. You didn't tell the prosecutors that. First person to hear that. That changes the whole complexion of that keystone in this chart is missing. The arch falls down. As I said, the prosecutor said she could not. And it'd be great if that were true, they'd have a good case. Problem is, like the bullshit. Absolutely could have done it herself. What I'm asking you to do is read the judge's chart. It's complicated, but it breaks down 7 different elements. 3 of those that he knowingly and intentionally violated a condition of family violence law. Did he do that? No. That he committed an assault by striking her with a wire. The evidence goes both ways on that. It's possible she could have done it herself. Candidly, to look at it and try to visualize how a person coming from behind would whip a person, how could there not be any mark past the back? If the wire would wrap around, there would be frontal damage. There was none. Or, as Denise said, I don't remember. I don't think I ever checked. I don't think I looked in the mirror. Come on, ladies. You've been whipped. You got mirrors in your house. You're going to look at it. Put it there yourself. We ask you on at least 3 different elements of this charge. It has not been proven to be beyond a reasonable doubt. We ask you to do it.
All right, State.
Yes.
What this case really boils down to is no. That the defendant wouldn't take no for an answer. No, you cannot keep contacting Denise Valdez. No, you cannot keep assaulting Denise Valdez. And unfortunately, the defendant in this case refuses to take no for an answer. So I think both Michelle and Mr. Young talked about some of the elements that are not contested in this case. I just want to go over those with you because it appears that we're on the same page here. So number 1 is the parties involved. There's no question that that's Denise Valdez, that is Anthony Salinas, that they used to be in a dating relationship, that they had 2 kids together, right? There's no really question about the parties and how they relate. There's not really any question about the date of the offense. I haven't heard anything about August 13th or August 15th. It's all about August 14th of 2021. So that's really not in contest here. That the address here was in Bear County, Texas. Again, not contesting that. That the bond that he violated was a bond on a family violence case. That's why we put State Exhibit 2R in front of you so that you can see, hey, this is a family violence case. He's pointing a gun at her. They're in a dating relationship. That's standard time. It's pretty clear. That the case number, I know it's something seems silly, but the case number CM70892. There's no contest about that. That a no contact order as a condition of bond is a bond condition that is related to the safety of the victim. That's kind of intuitive, I think. I think it's like people can understand that. But even you had Detective Roll will tell you that is a bond condition related to the safety of the victim. So that's not really in contest here as well. That Denise had those injuries on her back on August 14th of 2021. Nobody's contesting that. Right. And so, and then I was also contesting that the defendant went previously to prison twice for assaulting Denise Valdez, right? So what this really boils down to, as I'm understanding Mr. Young's argument, is that an assault didn't occur. It's not that I did it in self-defense. It's not that he didn't know about the bond condition or anything like that. It's he just didn't do the assault. He didn't physically assault him. Okay. So let's talk about the safety evidence for a minute. So we have again the 911 custodian. You'll have safety to the 5 with you. If you want to listen to that again, go ahead. It'll be back in the jury room with you. What also you got from the custodian of records is what time that phone call was made. She told you it was at 5:44 p.m., which is important for the timeline of when this could have happened, despite the defense's witnesses. Then you heard from Vincent Bianca, who is a fingerprint examiner. He's testified many times as far as doing the examinations and telling juries and judges and prosecutors and defense attorneys that these prints came from the same person. So he tells you, hey, I took the print from him today. I matched it to the prints when he was booked on these. Those are the same. This is the same person we're talking about, the same Anthony Salinas. So he's able to print in front of you, which is Exhibit 1, 2R, 3, and 4. And so those are important in different parts of this case, but you'll have those back with you as well. I want to spend some time talking about Denise Valdez. I think we have a Southern phrase that bless her heart. And that's how I kind of feel about Denise. I think she's easily confused. I think she's not the most eloquent, the most educated, the most bright person. But again, like we talked about for Dyer, the law protects every victim, right? Regardless of whether you like her or if you don't like her, it still protects her as a victim in these cases. And so, I also want to talk about the fact that she might not be the most eloquent. You saw on cross-examination, she had a little bit of difficulty with lefts and rights, and maybe that's nerve, excuse me, maybe that's just a little confusion, but I think she's obviously a straightforward, honest person, right? She could have told you something differently. She could have completely argued with the defense about every fact. But no, she was straightforward. When she needed to concede a fact, she would concede a fact, right? She doesn't know who's going to testify. I didn't know who was going to testify for this case, right? This is the first time I'm meeting any of them. So she could have lied and made up all these facts, but she was truthful here today. As far as having contact, like the defense told you, they have 2 kids in common, right? And she told you that as well. Regardless of what part of their life they're in, they are going to be part of each other's lives to a certain extent based on the fact that they have 2 kids. And so, I mean, those kids are older, but I think there's parents on this jury that just because you turn past 18 doesn't mean that you're still not going to have or know or have to maybe ever communicate with the other parent. I think what also makes this case and her testimony put it into context is she's been a frequent domestic violence victim at the hands of this defendant, right? She told you about the 2 cases that he went to prison for, and look at the sentences. 2008, he went to prison for 102 months, which I had to divide because I'm not great at math. Turns out to that 8.5 years, and that was in 2008. So presuming he does his sentence, comes out, and then he picks up another family violence case in 2014 against her, and then is sentenced to 2 years on that case, right? So she's a frequent flyer about assaulting Denise Valdez. And so, bless her heart for not being able to distinguish every single time. She tells you he's controlling, he's manipulative, and he hurts me a lot, right? So really what Denise boils down to is that she's able to tell you what happened that night. She never wavers on the fact that I was outside walking away from him and he struck me on my back 2 times with the cord. And then you saw the injuries that she had. I think those are the injuries she had. And then Officer Wallace tells you those injuries are consistent with somebody being hit with a cord, right? And from his perspective, as having to deal with when he's on shift, I believe he said every other night, at least he's responding to a family violence call. So he's, again, frequently dealing with these cases. What he tells you is that this was consistent with somebody hitting with a cord or a wire. And that, to me, it didn't appear like it was self-inflicted. In fact, it was a fresh wound because when I saw her, it was still bleeding, right? If you also listen to her testimony, you back in those states exhibit number 5, her statement again is consistent with statement number 5. Over my house, strikes me. Again, she's consistent about who caused these injuries, when they were caused, and how it felt, right? It hurt, it felt like it was stinging, like it was burning, right, where she got hit with it. And look at that injury. If that had that swelling, that bleeding, I feel like that's a pretty consistent degree or sensation of what you would feel. Defense took some time talking about, well, we didn't bring in the deaf and mute daughter to testify. Well, duh, right? If she can't talk, how is she going to testify? And that's what Denise tells you, isn't it? Right? Next, I want to talk about is Officer Wallace. So, again, he is frequently called to these types of cases, investigates them initially, and works and talks to all the parties, right? And he says, I talked with the witness, I talked with the daughter's friend, and after talking to both of them, the stories were consistent, right, with one another. And that their testimony, what their statements were also consistent with the evidence in this case, right? So no problem with what they tell them at the scene. And again, the injury, he's seen multiple injuries, obviously, having dealt with many of these cases, and he tells you exactly what it looked like. It was fresh, actively bleeding, and in his opinion, did not look like it was self-inflicted. And then we have Detective Rolo, who again just kind of reiterates what Officer Wallace says, that statements are consistent, and again, he also tells you obviously that the bond conditions relate to the safety of the victim. So, to believe the defensive theory is to believe that Denise Valdez made up the story, she inflicted the wounds on herself, and that she did it to gain nothing. What does she gain by testifying here today? She had to take off time from work, she has to come in here, deal with the cross-examination. Obviously, she was nervous when she had to testify, having to do all of those things. And to gain what? They don't have, their kids are older, so it's not like it's a custody issue, right? She just wants to be left alone. And that's what we're trying to do here today. So we'll talk about the defensive theory of the case and the witnesses they brought you. Again, they brought you witnesses, they don't have to, but for some reason they did bring and they brought these witnesses, which I can't quite understand. First, they have Rebecca Menchaca, our convicted felon. When she testifies on direct examination, she says, oh yeah, we're coworkers, that's it, right? And it's until cross-examination, like you've known this guy for 20 years, right? He picks you up at your house, you know his family members, you know Denise apparently, because you know where she lives. That's kind of odd, right? She's not friends with Denise, but she knows where she lives and she knows when she moved. All she can really tell you is that the last time she saw the defendant was about 4:15 p.m. And then I asked her, hey, so if the GPS shows him at the house at 5:17, about 5:25, 5:26, you can't tell me the defendant wasn't there. Oh no, right? And again, that timeline is consistent with the 911 call as well, which happened at 5:44 p.m. Then we had Amy Sanchez, who I guess was there to testify just that he was here in Barrett County on August 14th, 2021. As I really don't understand the other point for testimony. I saw him at 8:30 when he left the house. Okay. Do you know where he was the rest of the day? No. Were you around? Did he be assaulted? No. So I can't really tell you anything. Okay. Well, thank you to let us know that you left the house at 8:30. I mean, that's an opportunity and an ability to commit this crime. Okay. And then they brought for you finally Crystal Salinas, the defendant's niece. She says she saw the defendant at the bar. Okay. Well, what time was it? I can't really remember. Okay. Well, if the GPS shows at that address about 6:18, does that sound about right? Yeah, that seems like it'd be right. So really, we have all of their witnesses show you between 4:15 and about 6:18 that nobody can tell us where he is. So again, that's the time frame in which the defendant assaulted the victim and here with the court, right? So I guess the defense's witnesses were good in the sense that they were able to narrow down the timeline for you and provide consistent testimony with safety exhibit number 5, which is the 911 call, the police report, when officers responded to the scene, as well as Denise's testimony. So what also Crystal told you is that the defendant cut his monitor after he received a phone call, right? If he didn't do anything wrong, I think it's pretty clear. If you cut your GPS monitor, that's not going to be good for you staying on phone, right? Or staying on GPS monitor, right? You don't think the court's going to do anything about that? Or it's because you know you did something. You want to cut your monitor to make sure that you don't get picked up, right? That makes a lot more sense. So nobody can tell us where you are, because that's what guilty people do. Is they don't want people to find them. They want to get away to make sure that they're not found. That's exactly what he did in this case. So thank you, Crystal Salinas, for confirming that detail for us. So the defense spent some time talking about green truck versus red truck. Well, this is what I talked about before now about reasonable doubts, right? Okay, it has to apply to the elements of the offense. There's nothing about trucks in the indictment that he was in a green truck when he picked him up, picked her up, or whatever it is. Even if you buy the defensive theory of this case, is that they place her there as well. It's clearly a confusion about which truck she saw. It's about a year later. So sorry that her detail isn't as good as saying whether it's a green truck or a red truck. So what this boils down to is that, and the only thing the defense again is contesting is whether the assault occurred. And I think it's extremely clear from the evidence that the assault occurred. She had the injuries. She said who caused them, when they were caused. She's understandably afraid of this person. And you have that in state exhibit number 3 and 4. He frequently is hitting her, causing the injury to her. One of those is even hitting her with a baseball bat. And so it's clear that she would be scared of him and might not be the best to testify of him here today, or yesterday. Overall, the evidence is clear. The defendant committed this offense. He knowingly and intentionally violated the order by assaulting her, regardless of whether she was at the top of the banner or not. That's not the focus of the case. The focus is at the house when he hits her with the water, right? You intentionally or knowingly hit her. You contacted her, right? When you shouldn't. That's what the state's case is. Not that they were at the top of the banner. That's not what I'm worried about. I'm worried about him hitting her at her own home when he's not supposed to be around, and that he continues to assault her despite even being sent to prison. So we're asking you to retire to the jury room, select a presiding juror. The evidence will be sent back to you if you need to review it again. Take your time going through it. Make sure that we have a unanimous decision on this. But I think once you look through the evidence, it's clear that the defendant committed this offense and he's guilty. Thank you.
All right, ladies and gentlemen of the jury, you have all the evidence. You've heard closing arguments for both parties. You now have the court's permission to deliberate. The deputy will take you to the back. I need Kimberly Lawson and Alberto Rivera to remain behind, please. Everyone, please rise for the jury. Deputy, we can find. All right, is there a Gilbert Rowland here? Gilbert Rowland? Samantha Saldana? Ruth Ann Espinoza? Luz Marino? And Jesus Perez. All right. All right, then we're going to take our recess. Mr. Young, just make sure that we have your information so that we can. All right, thank you, Mr. Young. And so we will start up at 1:30, and of course, we'll be